So welcome to everybody. First of all, thank you very much for IBDiC, in the name of Victor, for the invitation, for the kind invitation for me to participate as a moderator in this panel. Many of you know that I've done my PhD thesis on the issue of place of arbitration, so I'm very fond of the subject. I think it's an incredible topic together with applicable law. Those issues are so important, are the two main issues of an arbitration agreement, that it's certainly a good advice for someone that is drafting an arbitration agreement. And whenever you're not very aware or you're not very used to the choices that you're making in relation to law or in relation to the place of arbitration, that you consult with someone from that place of arbitration and from that jurisdiction. We will see from the speeches of James and Victor that they are crucial. You may lose a case if you disregard some provisions from applicable law, and you may have a very hard time to enforce an award, or even have the risk of having an award set aside if you choose poorly your place of arbitration. So especially, and that's the main topic that we are going to address, especially in major construction agreements, because there's a site full of people, full of things going on. The evidence is in a special place or in one of the jurisdictions. So how we are going to address the issue today? Victor is going to give the perspective from the Brazilian side, and James is going to give us, James Pickavance, it's a partner from Jonesdale responsible for the construction contracts area. He's going to give his point of view from English law. As you all know, London is one of the major places of arbitrations in the world, and London also concentrates a lot of issues in relation to financing and insurance that also have to deal with major contracts. So in our preparation, what we have done, Victor is going to give a brief overview on the issue of choice of law, applicable law, and then he is going to speak about some details in relation to Brazil. Then we will give the floor to James to do the same in relation to applicable law. And then we will switch the major items, and then we'll give the floor to James to give an overview on place of arbitration. So, having said that, I thank, again, Victor and James, thank you very much. Victor, the floor is yours.
Thank you, Adriana. And thank you, James, also for agreeing to do this webinar. I think it's a very interesting discussion, and especially because when we are dealing with choice of law and choice of seat, as a construction lawyer, what I see is that usually the parties doesn't care about too much about these clauses. These clauses are left to the end of the negotiation, are called the midnight clauses, and usually this creates a lot of problems later on, because this especially these two issues could have a big impact on the ability of the parties to enforce their rights and really enforce what was agreed in the construction agreement. So, giving a quick overview about choice of law, as I mentioned, usually the parties, when are discussing choice of law, they focus only on the issue of neutrality, or they want to have the benefit of using their own law in the contract to govern the contract. So they just focus the idea on this during the negotiations. From my experiences, this is the drive of the parties when they are negotiating the agreements. And frankly, I think this is the wrong approach. I think sure that it's important to search for neutrality or even to look at the jurisdiction that is more well known for each party, but other issues should be considered. And especially in construction projects, which are very complex. And as James knows, there are two certainties in construction projects. One is that change orders will occur, and the second, that is highly possible that a dispute will occur. So when I was doing a research about the main reasons why the parties try to define what is the choice of law, I found a very interesting survey that was done by Gustavo Moser from the London Court of International Arbitration that shows that the two main factors that drives attorneys, especially the international attorneys, to discuss the choice of law is the legal certainty and the freedom to contract. So these are drives that factors that really affect the parties in the end of the day. And I consider that these two issues, I would like to explore a little bit these two issues, especially in relation to the impact of the choice of law in the remedies available to protect the parties and the project, and also the impact of this choice in relation to dispute resolution, especially international arbitration. So when we deal with the impacts of choice of law in the remedies available to protect the parties' rights, I believe that we should understand that even if you hire the best attorney in the world, the contract will not foresee and will not cover all situations that may occur. So all this not ruling situations would be covered by the applicable law. So it's very important that the parties understand that, because even if we use a FIDIC model, or which is a contract that is being tested and used for forever, and also the contracts that are like 100 pages contract, these contracts will have some gaps. And these gaps are filled by the applicable law, the substantive law. So, for example, if an international construction contract does not rule what type of damages and what type of that are not covered by the liability of the parties, if this provision is missing in the contract, then the governing substantive law would rule this issue. And for example, there are some countries that accept the concept of consequential, indirect, and punitive damages, but others not. So this shows how the governing law, if in these cases in which the contract misses the information, how this could affect, because this would have a direct impact on the ability of the party to claim specific damages against each other, which is totally usual in construction projects. Also, the choice of law sometimes could impact even in the provisions that are established in the contract. So, for example, in some specific jurisdictions, such as the civil law, such as Brazil, some statutes limited the freedom to contract. And these limitations could affect the provisions that were agreed between the parties. So this shows that you can have the best contract in the world, but sometimes the governing law could change the relationship and what has been agreed and what has not been agreed. So I believe that this is unquestionable, that the importance of to have a strategic thinking on the definition of the choice of law, especially in relation to these issues. And with regard to dispute resolution, I believe that also the choice of law has a significant impact, as depending on the law that is chosen, this law could be friendly or not to the method that you're using. So some jurisdictions, some laws are not arbitration friendly, others are. And so this have a critical impact on the ability of, first, initiating the arbitration proceeding, and second, enforcing an award if possible, or using other measures that are available. So for sure that that as we can see, and the discussions, a lot of discussions is there, sometimes the governing law of substantive law of the contract is the same of that applies to the arbitration clause, but sometimes not. So depending where you are, this also affects in which country you are. For example, James are going to talk about London, but also in Brazil. So if you don't have a specific law foreseen in the arbitration clause, so what law would apply? Is the governing law, or is other, or is the law of the seat? So all these issues could have a major impact in a construction project. As I told you, the existence of the dispute is almost certain. So based on these concepts that I just mentioned about in this overview, I would like to go a little bit deeper in relation to Brazil. Brazil is first in relation to these two subjects that I was discussing. So first, in relation to the remedies available to protect the parties, I would like to really focus on the issue of the freedom to contract and the legal certainty. As I mentioned before, the freedom to contract is the main factor that that the parties consider on when they are choosing the governing law in an international contract. So the parties look for jurisdictions and laws that really understand that the contract is the law between the parties. This principle of pacta sunt servanda is applicable in Brazil. However, the Brazilian Civil Code established some limitations to such freedom, especially related to two principles. The first one, the social function of the contract, and the second, the possibility to review or terminate the contract due to unforeseen circumstances. Such limitations have a great impact in the construction agreement, as, for example, fines, liquidated damages, or other relevant contract provisions could be easily declared null if they are considered unreasonable. And this shows a little bit that what has been agreed, and you know, James, how many hours you spend negotiating a liquidated damages and a penalty clause. It's crazy. Sometimes it takes days to really agree in a clause like that. And in the end of the day, such negotiation, and which really reflects the will of the parties, could be easily declared null due to this provision if this is considered unreasonable. And also, a contract that sometimes have usually the international construction contract have a limited hypothesis of when you can terminate or where you can review a contract. But this could be totally changed considering the law if unforeseen circumstances happen. So these situations created a lot of uncertainty to the parties to really accept the Brazilian law as the applicable substantive law. But recently, a new law was issued called the Economic Freedom Act that was issued in 2019. That was issued exactly to try to change this concept and to bring again Brazil to be in line with the freedom to contract concept in order to really attract the foreign companies and to really consider doing business in Brazil, and second, considering using the Brazilian law as the applicable law in their contracts. So what this law changed? The first thing that this law, which is very new and has not many precedents in this regard, they established that in private contractual relationships, the principles of minimum intervention and exceptionality of contractual revision shall prevail. So this is like a mantra and a music to everyone, to all parties that want to have the freedom to contract. For sure that this provision has not been tested yet, as I told you, because it's so new. We don't have not even 1 year of this law. But I believe that this is a path to really bring back this legal certainty and really have the freedom to contract consolidated in Brazil. Also, this act included the Article 421A to the Brazilian Civil Code that really impose that this right to review the contracts in cases which are not foreseen in the contract should be really exceptional. Again, is much more a principle than an effective change, but I believe that this shows that the Brazilian lawmakers are considering that this change and wanted to really bring back the legal certainty to our law and to the international contracts. They use the Brazilian law as the applicable law. Also, in relation to the impacts on dispute resolution, I believe that Brazil is one of the most arbitration-friendly countries. We have a law that is being tested and passed to all types of scrutiny of our courts and has been consolidated for 24 years and is partially based on the Uncitrol model of law. And also, so this consolidation, and also because Brazil is signatory of the New York Convention, this, I believe that for the purpose of having the Brazilian law as the governing law related to dispute resolution brings a lot of safety and to the parties when they choose it. And I would like just to point out some aspects very fast. I know that I've been talking a lot and I want to leave James the word, but some issues that are very relevant for people that are not aware about the Brazilian arbitration law, that really shows how arbitration friendly we are and how safe our system are in relation to arbitration. So first, I'd like to point out that the scope of arbitrability in Brazil is very wide. Second, the parties are unrestricted to in the choice of the law applicable to the merits of the arbitration proceeding. Third, the parties have complete autonomy in selecting the arbitrators. who shall rule upon the claims. Fourth, the parties are entirely free to choose the arbitration institution. Fifth, both positive and negative effects of the competence shall apply. So the arbitration can rule on its own jurisdiction, and the courts cannot decide on the arbitration jurisdiction challenge before the arbitrators. The arbitration award also shall have the same effect on the parties and their successors, and are enforcement instrument, which is very relevant regarding the enforceability of the award. Also, there's no possibility of appeal against a decision that was issued by in accordance to the Brazilian arbitration law. And finally, I believe that one issue that is the most important is that the Brazilian courts have been showing that a pro-arbitration approach. So right now, we don't have much more discussions in courts about if you can arbitrate or not, even in relation to when you have a state entity involved. And there are very few cases in which the courts granted anti-arbitration injunctions, which shows that we have a safe place and a safe law to be applying to international contracts. So these are the general comments that I would like to give, Adriana and James.
Thank you. Very interesting, Victor, especially when you mention the provision 413 of our civil code. I think that's an issue. When we will get time to discuss a little bit, I would like to hear from you if there are ways to mitigate such provision. And if the parties can put in the agreement some wording to guide the arbitral tribunal to interpret the penalty and not to reduce if it's the case. And then I will move to James. James will start by commenting on the applicable law. And then James will present an overview on the issue of the place of arbitration and then comment on that as well. James, I would like only for you also to comment on something that Victor mentioned, which is the hardship issue, the possibility in a circumstance like the one that we are living currently, the pandemic time, for a court or an arbitral tribunal to review the agreement. Why I would like you to touch on that, because although obviously it's in our law, we have inserted it in our civil code because it's a legal theory applicable in various countries, and I imagine also in UK. So if we have this in our law, most likely we will see the same in your country. Please, you have the floor, James.
Adriana, thank you, and thank you to Victor. I'm thrilled to be speaking to the Institute today and delighted to be sharing the floor with Victor and Adriana, both of whom I'm sure you all know are erudite members of the domestic and international construction law community in Brazil. So really a thrill for me. I'm going to start with English law and touch on some aspects of it, but let me start, if I may, with some statistics. There was a survey conducted by the ICC a couple of years ago, global survey, 12,000 participants, and the question was, one of the questions was, which is your most popular choice of law? And the results of the survey showed that English law, Swiss law, French law, and New York law were amongst the most popular. But of those choices of law, English law was the most popular by a factor of 3. Now, This was a survey done by the ICC. Many of the participants would have been European. Would the results of the survey been the same if it was done by a South American institute? Perhaps not. But what it demonstrates is that English law is extremely popular, certainly in a construction law context. And some evidence of that lies in my work in the construction team in James Day in London, where predominantly the disputes that we deal with, contracts we deal with, are international, either international parties or international companies. I think the nucleus of that interest with the law, to my mind, derives from a few things. Firstly, the common law system in England has over time developed. It moves, it deals with innovative deal structures and changes in the commercial environment. It does not just stay still, and that is a result of the court structure, particularly the appeal court structure, which allows the law to move. Secondly, and we've touched on this already, the law provides that contracts are to be interpreted literally in their business context. In other words, the number one sort of principle that the courts will apply and English law applies is that the contract is king. So if the parties agree a bargain and agree a certain allocation of risk, then that bargain will be upheld by the law, by the courts, save for in extreme circumstances. And that is why I'm told, as Victor highlighted in his introduction to law, what parties focus on when they're choosing choice of law. What does that mean specifically in terms of English law? Well, important clauses like limitation and exclusion clauses, disclaimers, non-reliance clauses mean what they say. There's very little that the mandatory laws prevent the parties from agreeing. And that is not the case in a number of other jurisdictions. There's very little that the law implies into contracts. There's little mandatory legislative intervention for principles like public policy or looser doctrines like good faith. And we know that public policy and good faith does play a part to a greater or lesser extent in laws of other jurisdictions. Of course, the popularity of English law has really been made possible in large part by the judiciary, who all of whom are carefully selected and I think renowned, at least to my knowledge, as being highly skilled and incorruptible. And they tirelessly, it seems, churn out judgments which allow parties or advisors to be very specific when they are being asked, what does that clause mean? Or how is this dispute going to be resolved? Because there is an ocean of case law precedent publicly available on the internet that allows parties to advise very specifically on what the law means, what a particular provision means pursuant to English law. Within the context of construction, and that's what we're talking about today, there is, of course, in England, a specialised court or courts called the Technology and Construction Courts. And those courts are dedicated to the resolution of construction disputes. So the result is that there is a sort of highly specialised market deriving from this body of construction law that has been developed. That point's really been brought to my mind again quite recently. I have a case, it's a hundreds of millions dispute in relation to an oil refinery in Saudi Arabia, Swiss law contract, Swiss seat. And we engaged local counsel to advise on Swiss law. And what was clear to me in the discussions on some of the putative topics that you, Adriana, and Victor will know about, prolongation, disruption, concurrency, extensions of time, and so on, is that actually under Swiss law, these topics are not that well developed, or certainly not as well developed in as they are in English law. They're just not dealt with in the same level of detail. And so that's a snapshot, I think, of some of the things to think about when people ask me, why should I choose English law in the context of construction disputes? And I'll say just in closing, conscious of the time, that we've prepared a sort of summary go-to guide comparing the different laws of a number of jurisdictions, including England and Brazil, and I'm happy to share that with anyone in this presentation, not least because we can't get into the nitty-gritty of exactly what it means to choose English law. So, Adriana, with your permission, what I'd like to do is move swiftly on to choice of seat, which is the second topic we're discussing today. Thank you. Let me say a few words by way of overview, if I may, about the choice of seat, so that we're all on the same page. I hope we all know on this call, on this presentation, that the arbitral seat plays a pivotal role in international arbitration. There are a variety of arbitration regimes in force around the world, and selecting one over the other may have dramatic consequences on the procedure and sometimes the final result. Now, the arbitral laws in many jurisdictions are harmonising, that is right, but there is still a divergence amongst even the putative seats of arbitration in terms of arbitration rules. What does arbitration seat mean? Well, at its simplest, it's the judicial seat of base of the arbitration. And so if you select Sao Paulo or London as the seat of arbitration, then you are submitting to the national laws for the arbitration, for the procedure of the arbitration. And it's the law of the seat which will define not only the procedural aspects of the arbitration, but also will import some mandatory provisions into the arbitration that will apply regardless of the contrary stipulation in the arbitration agreement. I'm going to try and share two slides with you now. Try and fail, probably. Let me see if I can do this. So this is a slide taken from the 2019 International Arbitration Survey, and this was a survey on international construction disputes. And if you've not seen this survey, I'd recommend looking at it. You can Google it, it will pop up immediately. It makes for very interesting reading. The respondents were from across a range of sectors and geographies. The respondents indicated that projects that had fallen into dispute and thus were the subject of this survey, about 1/4 of those came from South America. So I think the survey is definitely relevant in South America, albeit it has global reach. And they were asked which seat they would choose for arbitration. You can see the results on the slide. I stress this is for international construction arbitration. Of course, it would be different for domestic arbitration, and over half of the respondents were from Europe and Asia. So the results, I'm sure, would be different if it was more localized to South America. But nevertheless, as I say, 1/4 of the projects that were referred to in this survey were from South America, and I think this provides a global overview of the party's preference when it comes to choice of seat. This second slide just gives a quick snapshot of some of the general factors that are taken into account when parties are thinking about choice of seat. And again, this is taken from the survey that I referred to. Again, it's the, if anyone wants to take a note, it's the Queen Mary University of London International Arbitration Survey 2019. And these are, as I say, these are some of the thoughts that the respondents had: general reputation and recognition of the seat, neutrality and impartiality, national arbitration law, cost, language, and so on. I'll leave that slide up for a moment so you can study it. Turning then to choice of London as a seat, why do companies do that, and what does that mean? And I'm going to give you 3 points on each of those, on the why and what does it mean, albeit there are a number of other points to be made. I think the first, and we touched on this already, is the neutrality and impartiality of the local legal system of English law. Law and seat do not go hand in hand, but often they do in contracts, because parties believe that if they're choosing English law, then it is more suitable to choose London seat. And they might choose London as a seat for similar reasons that they choose the governing law as a seat, and that is the neutrality and impartiality. The second, I think, is the hands-off approach of the English courts. The courts support arbitration wholesale, and they do their best not to get in the way. That said, there is a law, as there is in every jurisdiction, that governs arbitration, and in England it just so happens to be called the Arbitration Act 1996. And again, that predominantly supports the procedure of arbitration, and which is usually institutional, and will not intervene. But there are some mandatory provisions, and they deal with essential matters such as the power of the English court to remove arbitrators, the general duties of the tribunal and the parties, enforcement, challenges to an award, section 68, 69, Adriana, I think we're going to come on to that later. And by selecting England as a seat of arbitration, these mandatory provisions will apply, independent of the content of the parties' agreement. The third reason, I think, is the artillery, if I can put it like that, the artillery of legal talent. And I mean that in the broadest sense, not just lawyers, but experts, industry consultants, all of whom are fighting their client's corner, and of course arbitrators. To my mind, at least, and I've been about a little bit, so to speak, no one place comes close to matching the scale and bench strength of the legal community for construction that we find in London, and that's particularly so for construction. There are thousands, it seems, of very sad individuals like myself, whose only focus is construction law, and international parties find that attractive. There are other reasons: geographical convenience, infrastructure, English as the first language, but I would say those are the main three. As to what it means, well, there's a few points. The first is, and this comes up quite a lot, how are submissions made in an arbitration? In a civil law context, submissions might be made in what's known as memorial style. So the claimant will not only serve the statement of case, the detailed document which sets out the case, but also expert reports, witness statements, evidence. That's memorial style. Now, in arbitration subject to a London seat, quite often the choice is what's known as pleading style, and that reflects the procedure of the English courts. And pleading style is an approach where only the statement of case is served, and then the defence is served in a reply, and thereafter expert reports and witness statements are served. And one perceived benefit of that is that the parties get to see the other party's case. There is an ability to narrow the issues before the experts put pen to paper. So that's one issue. Possibility of an appeal on a point of law is another differentiator. We'll come to that, I think. The predominance of ex-judges as arbitrators. Now, some people see that as a positive, some people see that as a negative. But as I said, in England, there is a huge pool of construction talent. There's a specialised construction court, and some of the judges that have been on the bench in that court then turn to be arbitrators, and so they are very clued up, as it were, on construction law. So that's a whistle stop of choice of London as a seat. Let me pass back to Victor, who is going to talk about choice of seat in Brazil, and then I know, Adriana, that you want to open up with some questions.
Okay, thank you, James. I think it was a very good overview for us that are not used to the London style, let's say. Victor, please, your comments on Brazil as place of arbitration.
Thank you, Adriana. After hearing James, it's very difficult to really talk about Brazil as a seat in comparison to London, for sure.
Not true, Victor, not true.
No. I mean, the number of disputes and how London is used as a seat is really in comparison. And basically, I think Brazil is, I think it's growing as a seat for international contracts, but people are still resilient on accepting sometimes because they are not aware about how Brazil, what are the benefits of using Brazil as the seat. So I would like to really show a little bit about, in a very quick presentation, about this specific issue, and focusing on three issues. One related to what are the definition of the nationality of the award with the consequence of the enforcement, the influence of the seat in the applicable law in comparison to London, and also some non-legal factors which were very well addressed by James in relation, especially with the institutions, arbitration institutions, the law of the place in which the arbitration will take the seat, and also in relation to the ability of the arbitrators and the reputations of these arbitrators that we have here in Brazil. So focusing on these three issues, using one of the major cities of Brazil, for example, São Paulo, Rio, and Minas Gerais, for example. There are other cities that have a culture of arbitration and also are used as the seat, but using one of these major cities of Brazil could bring benefits to international contracts. And one of the issues that I believe that brings effectiveness to the arbitration award is the fact that Brazil is signature of as I mentioned, of the New York Convention. So when you have an award issued here in a Brazilian seat, this could be enforced in the Brazilian domestic courts or in several countries, all countries that are signatory of this convention. So this brings a lot of confidence and comfort to foreign companies to really use this, especially when you're a company is hiring a Brazilian contractor, which happens a lot of time. The Brazilian contractors use it before Lava Jato had a great spread in their activities all over the world, and using sometimes the Brazilian seat in these contracts brings benefits to the foreign companies, especially because if they need to enforce an award against the Brazilian company, this would make their lives much easier and faster to really collect any amounts or oblige the company, the contractor, to perform some obligations. So in relation to the effectiveness of the arbitral award, I believe that it's positive to have one of these major cities as the seat applicable. Differently from London, James, in Brazil, the choice of seat has not the impact that in London you have in relation to the applicable law. So by just having the seat established in Brazil, in one of these major cities of Brazil, does not have an automatically impact on the definition of the governing law. So usually you have in Brazil the law, a specific law that applies in relation to the definition of which will be the law applicable in specific cases, and so the relevance, and I believe that we are going to talk about this maybe if we have time, but the case involving SulAmérica, the Geral case, shows a little bit how our courts and the London courts deals with the issue about the seat and the importance of the seat. But I believe that the non-legal factors are also, and also because of the Brazilian law, arbitration law, as I mentioned before, is very friendly to arbitration. I believe that some issues are very important to be highlighted. So, for example, those Brazilian major cities that I was mentioning, São Paulo, Rio, and Minas, have a significant number of reputed structured arbitration chambers, including branches of international chambers such as the ICC, which shows that some of them have a very desirable hearing venues, well-trained translators. So in relation to the structure and the rules of these chambers, I believe that we are very well served, and this helps a lot when thinking about using the Brazil, one of the cities, as the seat of the arbitration. Also, Brazil has a relevant number of reputed arbitrators, and we have Adriana here, which is one of them. And all these arbitrators are very experienced, and they have a good experience in international disputes. They have been working all over the world. So this also gives some comfort to when you need to and think about using the seat on Brazil, including some of these arbitrators are specialists in construction law, are fluent in English. So, for example, IBDiC, which is the institution that is supporting this event, shows how construction law is developing in Brazil, and how we have specialists and good professionals that could assist the clients in this respect. And also, it's important, I think, to mention that those cities, as I mentioned too, such as São Paulo, have specialized regular courts that deals with arbitration issues. So, for example, we have in São Paulo this specialized court. So at any kind of enforcement or annulment lawsuits involving arbitration goes to this specific court, which shows also that we are thinking about having specialists dealing with this situation in order to give more legal certainty to the parties when they choose the seat. So I believe that these are my comments. Just to give I don't want to spend much more time, but there was a huge increase since in the last 10 years of the use of Brazil as the seat of arbitration, and especially in relation to disputes involving contractual and construction issues. So the amounts that are being involved in these disputes are very high. So are billions of dollars, and also which shows that first, Brazil is a safe place to do arbitration, and second, that we are prepared for big cases and to deal with those situations like this. So these are my comments.
Thank you, Victor. just to start with our hot topics discussion, and I invite everyone to present questions. One issue that I'd like to comment is that 10 years ago, when we hosted the ICA Congress here, I remember an English arbitrator, well-known one, QC, and he was astonished by the vibrant community that we have here. And I asked him, would you feel comfortable to choose São Paulo as a seat? And he said to me, I will have no option. You know, in the future, you will be too big. And fortunately, if we look to the ICC data in the last 20 years, because modern English law is more than 100 years old. Brazilian, arbitration law, and Brazilian arbitration law is a recent. It's well developed, but we started 25 years ago. So we have done a lot, and there's still a lot to be done. But the fact, the data also shows that in the ICC perspective, we are very fond of ICC arbitration, much more than London Court, and we can discuss on that, James. Why is that? But we are the third country in number of parties, the third largest country using arbitration. In terms of place of arbitration, I don't have the data in front of me, but I think we are number 5 or number 6, and we've considered the cities of São Paulo and Rio de Janeiro. I've seen once at least that they are within the 10 first cities in the world, or the 20 major cities to be selected. So I think we have a lot to go, and but it's a safe place. Definitely, if we think as Latin America, when we think about Singapore, we are thinking about Asian countries. When we think of Latin America, I would say that Brazil, and especially São Paulo, it's a very good place. A few very follow-ups on what you have mentioned. First, 2 issues on law for you, James. The issue of the hardship doctrine, if you do have there, and in relation to some sort of interference in the contract itself. Is it possible for an English judge or English arbitrators to interfere a little bit on the wording of the agreement in relation of the limitation of liability in case of willful misconduct, willful breach, because it's the case in Brazil. Why I'm asking that? Because it may not be too different in the end. There are some differences, but it may not. So please, James.
Thank you, Adriana. And may I, before answering those questions, very quickly echo and amplify the comments of the QC you referred to, who came across to Brazil 10 years ago. There's no doubt that Brazil, as an economy, is an unstoppable juggernaut right now, which is bursting onto the world stage, and the arbitration community in Brazil is very well known in London and around the world. So I echo your comments that whilst the statistics which may derive from sort of tradition or perception suggest other seats as popular seats, there's no question to my mind that I would feel very comfortable resolving my dispute if I was an international corporation in Brazil. No question about that. To your question about doctrine of hardship, oddly that doctrine doesn't exist. I'm aware of it, but it doesn't exist in the UK. It's not something that has ever been entertained as something that will vary the party's rights or impinge on the party's ability to enforce an arbitration award. So I can answer that sort of fairly simply.
But not in relation to arbitration awards, to the contract itself.
Yes,
please.
to the contract itself, the doctrine of hardship does not apply in English law, and I know it applies and is relevant in other jurisdictions. And forgive me, your second question.
The question is in relation to the limitation of liability provision.
Willful misconduct, gross negligence. Well, I'm pleased you asked me about that, because I wrote a very long paper on gross negligence and willful misconduct recently. And the quick answer to that is no, that doesn't affect the parties' agreement. So if there is, so for example, in Germany or in France, if there is gross negligence or willful misconduct, then the law steps in. It does not step in English law. You can exclude both of those concepts, albeit, as we know, they are often they're often the exception to the exclusion. And in fact, 3 disputes that I've dealt with in the past 2 years, one in particular, has been all about one of the parties, the claimant, trying to get around, trying to get into the exception, trying to demonstrate that gross negligence and willful misconduct was committed. Very hard under English law. Willful misconduct, you've got to show intent, you've got to show recklessness, extremely high threshold. Gross negligence doesn't require intent, but is several steps beyond negligence. So no, it's not the same as other jurisdictions, and perhaps a sort of a further demonstration that parties are free to contract as they wish.
Okay, thank you very much, James. And Victor, please, if you can comment on that, on those issues in Brazil, also the gross negligence and willful misconduct, and if the standards are that high also for us to have some sort of revision of what's written in the agreement. And the other question that I had presented to you, provision 413, how to mitigate its in effect in relation to our applicable law. And just to one comment, Fabiana Versosa just confirmed to me that the data from yesterday by ICA shows Brazil in the 5th place as most wanted countries as place of arbitration, just behind England. So it's France, according to our ICA, ICC data, France, Switzerland, US, England, and Brazil, and then Singapore together with Brazil. So please, Victor.
Thank you, Adriana. So in relation to the limitation of liability, usually the contracts, the construction contracts, provided that this is an exception to this limitation. So when you have fraud, willful misconduct, or any gross negligence, which is a concept that we don't have in Brazil, but sometimes is defined in the contract, this the limitation of liability shall not apply. So usually this is ruled in the contract, and when it's not ruled, is a discussion that is subject to depending on what is the jurisdiction, and if it's on arbitration, sometimes the arbitrators understand that this factor, because here we have the good faith principle that that rules all contractual relationships. So if it's considered that a party failed to follow this principle, then it's possible to consider that to review this provision and say that this would not apply because there was a breach in this objective good faith principle that we have. But usually what I'm seeing in construction contracts, especially the big ones, is that you have express exclusion of the limitation of liability when in a situation like this, when you have willful misconduct or fraud or gross negligence. And also in relation to your question about how to mitigate when you have a situation of, because it is almost a must in any kind of construction contract, especially the ones that have long term to be completed and is in places that are inhospitable. The unforeseen situations would occur. That is almost in any kind of contract project like this is not possible to really foresee everything. However, sometimes, and this is something that also goes back to how is important to draft the contracts. We consider that is important to really put who is assuming the risk of some situations, and really encourage the parties to really disclose by means of warrants and representations about the knowledge of specific issues. So, for example, with regard to severe adverse climate situation. So, usually the contracts establish what are the parameters of considering what is not what's foreseen and what's not foreseen. So sometimes you insert a length of time in which you will consider that, for example, in 20 years, if an event occur like this in a specific period, then this is not considered an unforeseen situation. However, other contracts establish 5 years, and this something that parties can agree, and the parameters sometimes helps in the end of the day when the dispute occurs or when a claim comes into force. So really, you have, I believe that you can address these issues in the contract and include some provisions in order to first establish who's assuming each of the risks and have the warrants and representations showing really if a party is assuming a situation or not, and really including some specific details on what is foreseen and what is not. As I mentioned, you cannot cover everything in a contract, but the issues that mostly happen in contracts, construction contracts like this.
Thank you, Victor. We have discussed among ourselves a few questions, but before that, we move into that, there is a question from the audience that is addressed to you, Victor, from, the name is not here, but could you tell us what is the percentage of annulment of awards in the Brazilian courts?
It's very low. I don't have the percentage here, but just to, I didn't cover this in my speech, but the hypothesis of cases in which you can annul an award, an arbitration award, are very few. You have basically seven cases, and these are usually mostly formal issues. So issues related to formalities, the partiality or not of the arbitrator. So if the award affects the public order, so are issues that really focus on formal issues. So the arbitrator, the courts cannot go and discuss the merits, or this annulment lawsuits cannot really cover issues that focus on the merits, but much more formal issues. So this limits a lot the percentage of cases in which the courts have been annulling. But for sure, if you look at some specific states, I know that they are more pro arbitrations such as São Paulo. Others, you see a higher number of cases in which there were courts annulling arbitration awards, but usually is really focused on these formal issues, which reduce a lot the number of cases.
This is something that it's important to have a comparison, because first of all, I don't know who made the question, but the percentage is very low. Our community, since I was at the Brazilian Arbitration Commission, SEBAR, until now, we follow very strictly the annulments, and we go into the annulments and we check the decision itself. If it was properly annulled because it was a violation of due process of law or not. And we follow that very closely. We are very confident of the pro-arbitration approach, also in the main court in Brasilia, which is the STJ. And in a way that, and then I want to listen from James. James, from my perception, it's a perception. Whenever we discuss with annulments, it seems to be that a civil law country like Brazil, it's much more similar to Paris, to France. If we compare to English courts or American courts, in which there is a doctrine of some interference when there's a violation or huge violation from the arbitrator of the applicable law. From our side, it's a bit, I want you to explain Article 69 of the English Arbitration Act, and the few exceptions in which there was a discussion on the merits, because from our perspective, it's something that we don't have. And we are a little bit afraid of someone touching the merits. So please explain that to us.
Yeah, thanks, Adriana. Well, first of all, putting aside the appeal on point of law issue, which is the subject of your question, and I'll come on to, I think it's very similar between Brazil and the UK, or indeed any jurisdiction where arbitration is, the arbitration law is developed. That is pro-arbitration. The only grounds for overturning an arbitral award is jurisdictional grounds, or some sort of serious irregularity on the procedure. And I think that's broadly consistent from jurisdiction to jurisdiction if you're in a jurisdiction which has a developed arbitration law. And I imagine this is the same in Brazil. There's also a time limit on when you can challenge an arbitral award that has its seat in London, section 73, 70(3), 28 days from the date of the award. So it's not something that parties can just sort of sit on for months on end and then challenge it. If you've got a challenge, you've got to make it very quickly. The point you raise, and you're right to say that is different to a number of jurisdictions, is appeal on point of law. And this is section 69 of the Arbitration Act, and that provides that a party can challenge an award in the English courts on a point of law. And if the appeal is allowed, the courts can either confirm the award, they can vary it, or they can remit it to the tribunal for consideration, or indeed they can set it aside. It's important to set out, I think, how difficult it is to succeed on a point of law under section 69, and I can count on both hands the cases, or probably on one hand, the number of cases where an appeal has been successful. And I'll just read out the grounds in section 69, 69.3 it is, which have to be met before you can even get an appeal off the ground. And that is, first, there's a determination of the question of law that will substantially affect the rights of the parties. It's a question that the tribunal was asked to consider. And on the basis of the findings of fact in the award, the decision of the tribunal on the question of law is, quote, obviously wrong, and not all, but and is one of general public importance, and the decision of the tribunal is open to serious doubt. So I think where that leaves you is that it has to be a really obvious and serious error before you can get an appeal on a point of law, even off the ground. And for that reason, it's not at all common. In fact, it's very rare. You asked me a question offline whether parties can waive their rights to Section 69, and the answer is yes, they can. They can exclude that right to appeal on a point of law, and there's wording in the ICC rules, the ICA rules to that effect. You have to clearly exclude it. So it's not sufficient to say that the award will be final and binding. You have to say that the Section 69 right is excluded. But I think because it is so challenging to succeed on a point of law, it doesn't happen very often. So the exclusion or the waiver doesn't happen very often. Generally speaking, the arbitration agreement that's entered into is fairly vanilla, if I can put it like that. So to your point about it being a concern for jurisdictions that don't have appeal on a point of law, I think I can say with some confidence that that concern is misdirected, and that an appeal on a point of law, if it's going to be successful, it will be obvious to both parties that the tribunal has just got it majorly wrong. And in a sense, I suppose, from a policy point of view, and again, one of the grounds is public policy, to enhance the perception of the industry in choosing arbitration as a final form of dispute resolution, they want to know that the award, which may be an award for hundreds of millions or billions of pounds, as it sometimes is right. And if it's obviously wrong, then what the Arbitration Act says is, well, we'll have a think about that.
Okay, thank you. This is that's completely different from the French perspective. Let's say I'm not going to the depths of the word, even to check it if it was right or wrong. But it's interesting to know the difference. And for us Brazilians, what is important, what you said, is that if we fear that, just putting the agreement, waive that right.
That's right. Yeah,
that's right.
And you mentioned France. Although the two aren't necessarily connected, of course, the ICC is based in France. And as you know, the ICC court reviews the tribunal's award before, and some people like that, some people don't, because it adds to the delay. But they review the award before it's published. So in a way, that sort of serves the purpose that the legislation in the UK has sort of put in place. But it is different, and but exceptional.
Okay, thank you very much. And then we are 70 minutes above the time, but I would like also to give you a final question. We have so many questions to deal with, but especially we are dealing with international agreements, major contract agreements, and we are dealing with those choices that we have to make applicable law and place of arbitration. Whenever we discuss those type of agreements, there are related issues that play an important role. The financing of the agreements and insurance. So both of you explain for us a little bit the industry itself in relation to, because everything is very close to London, and it's possible that it also helps the development of London as a place of arbitration. and gives also certainty to the players. But explain to us how those related issues play a role here, please, James, and then I want also to listen to Victor's perspective.
Thank you, Adriana. The delegates probably think I've spoken enough, but I'm happy to answer your question. I think it does play a role to a certain extent. Yes, you're right to say that financing is a major part of the London economy. In fact, now most people would say that financing and banking is the bedrock of the London economy. And of course, insurance, a lot of the major insurance brokers are based in London. In my experience, does that impact on the choice of law or choice of seat arrangements? I think those discussions are quite separate. There will be an overarching individual or individuals that are lining up the financing and lining up the insurance. And as you know, when you're putting these deals together, there's a whole army of lawyers from these different disciplines. But I don't think, at least in my experience, and I'm not asked when I'm putting together construction agreements, to, for example, dovetail the choice of law and seat across all of those different arrangements, across the financing arrangement, across the insurance arrangements, because generally speaking, the source of disputes that arise from those different components of the project matrix will be different and relate to different things, and so it's not often I'm asked that question, but Victor may have a different view on it. I'm not sure.
No, it's an interesting question, Adriana, and I believe that the big problem here, in my opinion, all these related agreements should have the same type of dispute resolution method and the place of arbitration, because they are somehow related, and not only the construction in relation to the finance and the insurance.
Sorry to interrupt, but the insurance company doesn't want to.
Yes, that's the problem. And that's the big issue, because when we go to financing and insurance, basically you have standard agreements which are not negotiable. I'm not sure if you have already tried to negotiate with the insurance company, but it's not. There's no way to do that. So this creates a big problem. And one of the examples is the Sul America case related to the Geral, in which you had this situation. The policy, the insurance policy had mentioned a specific arbitration seat in London, and had the jurisdiction and applicable law in Brazil. So this created a confusion here. But in the end of the day, the problem was not related to the connection between the main contract and the insurance. But in my opinion, the parties should consider, and the insurance companies should really be more open to negotiate this specific clause, which is not a standard that should. I believe that the parties should, as it's the arbitration especially, is totally linked with the autonomy of the parties. So the parties need to really want to have that place and that law applying to the dispute resolution. I believe that this should be something that is negotiable, and if possible, having all related contracts, not only these ones that you mentioned, but also the subcontracts as well, with the same type of dispute resolution clause in order to facilitate and have the same without avoiding the risk of having different decisions about the same issue by different courts.
And we see this in, I think, if we look at the arbitral institutions, I think it's clear that they recognise this as a problem, because the changes in October this year to the LCIA rules, the changes coming into effect on the 1st of January with the ICC rules, those changes, there are other changes, but there are changes to the consolidation and joinder rules. And I think the institutions recognise that there are various stakeholders to projects and they want a consistent decision. It may be that the dispute is relevant to the insurance company or the financing arrangements. As I said, often it's separate. The financing dispute is separate, the insurance dispute is separate, but sometimes they're together. And in those circumstances, it makes sense, doesn't it, to have the disputes dealt with under one church. I think there is a move in the institution, certainly, to facilitate that.
Okay. Guys, thank you very much. I think for the entire audience, I think it's time for us to finish our panel and congratulate James Pickavance and Victor for brilliant presentations. It was an honor for me to moderate you two guys. It was a pleasure indeed. So thank you very much.
Pleasure certainly mine. Thank you very much, Adriana, and thank you to Victor. I'm enormously grateful to you both.
Thank you, Adriana. Thank you, James. It was a pleasure, and I look forward to do another event with you.
Okay.
Of course.
Bye-bye.
Bye-bye.